Ladies and gentlemen, we're going to just take a quick recess, allow you to stretch your legs, use the restroom, and as soon as you're all ready, we'll probably be ready out here to bring you back out so we can resume the trial. Thank you.
All right, Missouri.
Hold on, I think they're going to finish, and then I'll...
Sorry. But the issue of Mr. Connell is at this point still premature.
Okay. Attorney
So
Hinckley.
the purpose of an opening statement is to preview for the jurors what the evidence is likely to be. We heard a detailed account that only Mr. Argie would be able to give as to what happened on the night of the 3rd and the morning of the 4th, including detailed conversations between him and the victim and how allegedly the victim was found the morning of the 4th. If that does not come through a witness, counsel has provided facts that are clearly not going to be in evidence. That is an improper opening statement, and frankly, it's a prejudicial opening statement to the state's case.
As counsel knows, you'd need to have a good faith basis to be able to provide that kind of detail to the jury in an opening statement. This wasn't a minute fact; it was substantial detail. And now the state is suggesting it would only be through the defendant. I'm not sure that that's true, but I need an offer of proof from counsel as to your good faith basis for making those allegations. When I think through, I agree with everything you've said that Mr. Argie has the right, but to make that decision. But the reality is that, well, then what? I'm not going to require the state to go through a trial for nothing. I'm not going to have witnesses come in and testify under oath for nothing. And so I need to hear from the defense. And when I say for nothing, it's developing a record that then would later, in a second trial, would be material for impeachment. It's setting a trial up for failure right out of the gate. The detail would be prejudicial to the state. There's no way to unring that bell. So I'm going to turn back to defense counsel as it relates to the good faith basis that they have for that evidence. I can't. Yes, people can sit down in the... Mr. Argie, you can sit down. Thank you.
So as to our good faith basis for factual assertions made in the opening, at this time it is Bill Argie's intent to testify in his own defense. Further, we do not see that the information shared in the opening is overly prejudicial to the state. The state anticipated suicide as a possible defense. They raised it themselves in their own opening. But yes, as to the level of actual detail, this is information we would anticipate coming out through Mr. Argie's testimony.
Okay.
Well, that's what counsel's good faith basis is, and that's it for now. This maybe a mistrial motion be raised again down the line. So that was the first issue, Judge. The second issue is, again, although we suspected that the defense may be suicide, the defense never provided notice of that, and not that they're required to by any provision of law or discovery provision. But that advanced theory of defense places Maureen Argie's mental state at around the time of her death is squarely an issue, and information regarding that matter is now directly and centrally probative. So we have two aspects as to that. First, as to the prior evidentiary applications regarding the victim's state of mind, as to the marriage, the state of the marriage, and her future intent, such as, for example, the phone call to the police department a few days before and conversations that she had with family members and friends before. The proffered defense makes such evidence even more probative, as the evidence also refutes the claim of a suicidal mental state. was talking to others about her future plans. Also, Judge, evidence that we did not seek to elicit in the first instance now becomes highly probative given that suicide is directly in play given the defense opening statement and apparently their client's testimony on that. Specifically, the victim had 2 separate conversations with close friends in which she stated that she checked the house to make sure that the defendant did not have access to firearms. Both witnesses we intended to call in any event. Those 2 witnesses are Cindy Tanuma, and the conversation with the victim occurred in a face-to-face conversation on Saturday, March 30th. And the second witness is Megan Santos, and that conversation occurred through text messages on March 28th, and those text messages are actually State's Exhibit 96 for identification. Because of the defense that has been directly proffered in the opening statement, we now seek to elicit these conversations. As to any hearsay objection that the defense may make, they're admissible under Rule 803.3 as state of mind, as those statements reflect a mental state by Ms. Argie wholly inconsistent with suicide. And with respect to relevance, it refutes and rebuts a claim that the victim was suicidal. For those reasons, we seek to introduce these conversations that the victim had with Ms. Tanuma and Ms. Santos. We do note that Ms. Santos was a witness that we were going to be calling likely this morning, but should Your Honor need time to consider that, we'll swap her out and we'll call her on a future day. But we are making those applications.
My understanding is that the conversations the state wants to introduce are conversations about looking around the house for access to firearms. I disagree that that goes directly to Ms. Argie's state of mind at the time, or that it is directly contrary to any evidence of suicide at this point. It's simply a conversation about what Mr. Argie may or may not have had access to does not describe her future planning, it doesn't describe her mental state or state of mind.
Well, the court will take it under advisement, but the court disagrees. And, if there's evidence afoot that she was concerned about her death coming by the hands of the defendant, such that she wished to learn whether or not there were firearms at his disposal, it does appear to refute her interest in dying, and the proximity of those conversations to the claimed suicide, death by suicide that the defendant is claiming. I think the probative value of that evidence is high. So, into my 403 analysis, in terms of 803, it would show her state of mind, and it would be non-hearsay, but otherwise admissible under 403. So at this point, I find that it is probative based upon the state's opening and the detailed claim of the conversation and the defendant's proposed testimony of his multiple conversations with her and claim assertions of her state of mind that she, had in essence given up the fight at that point. So the court will allow. At this point, the court will allow it. I'd like to, I want to go back and read 803.3 once again, but based upon the detailed assertions in the opening, as to the defendant's alleged conversations with his wife, the court agrees with the state that Maureen's mental state is now at issue, particularly her mental state in and around the date of the homicide. Thank you.
So we would like a moment just to tell the victim witness advocate not to call Ms. Santos this morning, or if she's already here, to release her for today.
Well, I don't know that I need a lot of time. I'm going to just take a brief recess right now.
Oh,
Okay? Thank you. Anything further that we need to chat about?
No, Jim.
Okay, thank you.
All right.